Good morning, and welcome to Fridays with Frank, a lecture series sponsored by the Frank Church Institute at Boise State University. My name is Garry Wenske, and I am the Executive Director of the Frank Church Institute in the School of Public Service. The Frank Church Institute was established to honor the achievements and to carry forward the principles of Senator Frank Church. He delivered the first lecture on War or Peace, the American Role at Boise State University in 1982. Given today's challenges to democracies around the world, conversations like these are even more important. On behalf of the Frank Church Institute Board of Directors, our thanks to Oppenheimer Companies, C. Frederick Cornforth, and Community Development, Inc. for underwriting this series on how democracies survive and thrive in the 21st century. Today's guest speakers will address the rule of law, norms matter. Please welcome Chuck Rosenberg, former Chief of Staff to the Director of the FBI. Mr. Rosenberg has held numerous senior positions in the U.S. Department of Justice, including U.S. Attorney in Virginia and Texas, Senior Counselor for National Security to 2 FBI directors, Counselor to the U.S. Attorney General, and Administrator of the Drug Enforcement Administration. Currently, he serves as a legal analyst for NBC and MSNBC, Senior Counsel to a Washington, D.C. law firm, and as Adjunct Professor at Georgetown University School of Foreign Service. He is also host of a podcast, The Oath. Joining him this morning is Eric Barnhart, who retired as Special Agent in charge of the Salt Lake City Field Office after a 22-year career with the FBI. He also served as Special Assistant to 2 former FBI directors, Robert Mueller and James Comey. Previously, he served in the U.S. Marine Corps in the Middle East and Somalia. He is a member of the Frank Church Institute Board of Directors. Welcome, gentlemen. A reminder, if you have questions for our speakers, please click on the Q&A box at the bottom of your screen at any time during the session. Let's begin this morning with Eric Barnhart. Eric?
Thank you, Garry. Delighted to be here this morning for the Fridays with Frank lecture series. And again, welcome to those tuning in. I'm delighted to have my old friend Chuck Rosenberg with us this morning. Chuck, good to see you sort of in person, at least a face.
Always good to see you, Eric. Thanks for having me.
We've got, when we first conceptualized this, or first asked you to do this a couple months ago, I think we both thought, are we going to have enough material to cover an hour's worth? And I think as news continues to flow in every day, I laugh with Garry that we could probably settle in for the weekend and do a telethon, but we'll try and keep the most germane topics and cover those in an hour. One thing that I was made aware of is we have a number of students, both who are considering law school or potentially careers in law enforcement. And I think maybe just take a step before we dive into the material. You're currently an instructor at Georgetown, and maybe you could just, especially as part of your curriculum involves Frank Church and his work, if you could just kind of talk about that course for the audience.
Yeah, I'd be delighted. I've been teaching at Georgetown University School of Foreign Service now for 3 years. I love it. Find the students just sort of remarkably engaged and interesting. I teach a course on national security law and policy. So we look at everything from the Article 2 authorities of a president to military commissions, surveillance, detention, interrogation. But this year, for the first time, I actually had my students read selections from the Church Committee report, the committee that Senator Frank Church chaired in the Senate, looking at abuses of the Intelligence Committee and of the FBI. Because as I told my students, where we are now and where we may go is informed by where we have been. And I wanted them to understand that in some cases there's a difficult legacy. I'm proud of the work of the intelligence community and the federal law enforcement community, but as you know, Eric, it's not perfect. And I think people need to understand the history.
It's fascinating. You and I have spent collective decades in the department with the FBI, and how the work of the Church Committee resonates through time, whether it be the establishment of Senate and House oversight committees term limits for the FBI director, the establishment of the FISA court. It's played such a large role, I guess, in what we do. And then again, it's the important accountability piece for those of us that have served in the department, where our agencies that we very much love fall short and must take those corrective actions. So I'm sure a fascinating course for your students.
I hope so. I love it. I learn more from them, I think, Eric, than they learn from me, but I love teaching.
Well, excellent. I know, having been around you, that you're sort of a natural at that. So, diving into sort of our topics of today, the title that you and I came up with was Rule of Law and Norms Matter. And we're going to be touching on the theme of norms a lot today. And really, it's the notion, at least the way I see it, of what governs people like yours and my behavior in sort of the absence of the Constitution, statutes, or policies that are directly on point. And I think for a lot of folks, they just don't realize how much norms govern the actions of public servants, of people in public life. So that's a theme that I think we're going to be touching on, over time. One quick thing, if anybody out there, I know Gary mentioned it, Chuck hosts a podcast called The Oath. And for anybody that wants to hear interesting stories about how individuals came to serve in public life, their stories without politics injected into it, some of the most thoughtful conversation. Chuck hosts that. I would say this, whether he was here or not, you will be better and smarter for it. It is the best podcast out there. So if you like what you see today from Chuck, there's more of it out there. Real quick, Chuck, news overnight that the president and first lady tested positive for COVID-19. Obviously a horrific disease. We wish them and everybody else that's contracted this a speedy and full recovery. But already there's some talk about constitutional implications. And I know that's far down the road, but it is something that people are talking about, and specifically the 25th Amendment to the Constitution. Can you touch briefly just on how the 25th Amendment came to be, and just at a broad view, what that means?
Yeah, fascinating background. And like you, Eric, I wish everyone who's had that horrid disease well. 7.3 million Americans have been infected, 200,000 plus have died. So our thoughts are with everyone and anyone who has contracted it. Be careful. So going all the way back to the presidency of William Henry Harrison, who got sick and died. Was he assassinated? No. Help me, Eric.
I believe it was illness.
I think he got very sick at his inaugural and then died shortly thereafter. And there was an open question as to whether or not his vice president, Tyler, was actually the vice president who had just assumed the duties of the office of president, or whether he was actually now the president. And Tyler asserted he was the president. It was unclear. The Constitution didn't resolve that question. And it remained an open question for more than another century. After Kennedy was assassinated, there was some thought given to amending the Constitution to clarifying what happens when suddenly the president is gone. And the 25th Amendment, as you mentioned, Eric, made it clear that the vice president becomes the president. And then there's a procedure to fill the role of vice president. There's also in the 25th Amendment a provision that if the president is incapacitated for some period of time, the vice president assumes the president's duties. And it gets real complicated, and we don't need to go into detail. But there is actually now, thanks to the 25th Amendment, ratified in 1967, a mechanism for succession.
And of course, we're far from there. But again, I think as our audience starts hearing talk of this, and we're not there, but it's always important maybe to set that table.
Well, we're not there. I mean, the president is the president. He's sick, and hopefully he recovers. I would wish that for any president of the United States, regardless of party. But that said, remember George W. Bush twice passed the powers of his presidency to Dick Cheney when Bush was incapacitated. He was under general anesthesia, I believe, for 2 colonoscopies. And so the passing of the powers can be temporary and for relatively, benign reasons. But nevertheless, there is a mechanism by which a vice president can assume the office, either because the president has passed or because the president is temporarily incapacitated.
I think there's other instances of that as well. I believe that President Eisenhower passed those authorities for a time, I think after a heart attack and then a heart procedure to then Vice President Nixon. So again, it's comforting I think for a lot of us to know, hey, there's a structure in place that,
Yeah, and you're absolutely right about Eisenhower, but it was before the 25th Amendment was ratified. So there was still a bit of an open question about how to do it.
Yeah, you're absolutely right. It was more of at least in my reading of it, President Eisenhower talking with Vice President Nixon saying, take this over for a time. So now obviously ratified in the 25th Amendment. So again, that's probably just an overnight germane topic that we talked about. Just by way of background for our audience, you have a long career in the Department of Justice. I don't know the number of administrations and presidents you've served under and attorneys general from both parties. Can you talk just a little bit about kind of seeing it, working in the department so many times under both administrations?
Yeah, this may sound weird to members of your audience who know that we live in this hyper-partisan world right now, but in all of my time in the Department of Justice and under presidents and attorneys generals of both parties, as you said, Eric, we never talked about politics. The ethos of the offices in which we worked, it just never, ever came up. I think I told you a story the other day when I was an assistant U.S. attorney, so a career federal prosecutor, in my case, in Alexandria, Virginia, where one night walking out late, I saw a car in our garage that I had never seen before. And the reason I noticed it was that it had a bumper sticker on the back for a particular candidate of a particular party. I don't even remember who or what. But it startled me because, we never talked about politics in the office. You didn't see bumper stickers on cars. It turned out somebody was driving a spouse's car to work. But that was always the ethos of the office. No fear, no favor. Remember, the oath we take, and you know this well, Eric, you've taken it many times, is to the Constitution of the United States, to support and defend the Constitution against all enemies, foreign and domestic. It's never to a person. It's never to a political party. And at least in my case, I found people took that very, very seriously.
And I did as well. Man, again, you read the headlines the last couple of years, and I would say that a number of our former colleagues fell short of that in instances. But it is viewed very dimly. And it's hard if you haven't lived in that environment to know that is just sort of an off-limits topic. It's nothing anybody even thinks about. But, sadly, when people fail, they should be held to account.
I agree.
For what we do.
I agree. Human beings fail. That's sort of how we are built. We all fail at something. And there have been failures, and they've been high-profile failures. But again, the day-to-day ethos of the offices in which we worked wholly discarded politics, right? I never asked about the politics of anybody we were investigating or prosecuting. And I frankly never even thought about who nominated the judges in front of whom I was appearing. It didn't matter. They were federal judges. I think Chief Justice Roberts had made this point and has made it well, and it's worth reiterating. He doesn't think of judges on the federal bench as Obama judges or Clinton judges or Bush judges or Trump judges. They're just judges trying to do their best. And that is exactly what I found as a federal prosecutor in district court in Alexandria in the Eastern District of Virginia.
And I found the same thing throughout my career, obviously in the witness box and testifying in court cases in front of any number of judges. Wherever they came from, you all arrived at the same point. And it casts no shadow over what happened. You just didn't factor that into the equation.
Right.
So the rule of law, I think, sort of our title today, I think sometimes it's also made synonymous, though I don't think it is, with law and order. Can you tell us a little bit how you see the difference in those two phrases? Are they synonymous or are there differences?
They are not synonymous to me. Law and order strikes me as a political slogan, and politicians of both parties. Look, I'm a raging moderate. I don't take sides. I don't care about sides. But law and order strikes me as a political slogan. That's not how we lived our lives as prosecutors or at the FBI or the DEA. We lived it by rule of law, and it's a different thing to me. Rule of law, first of all, is a construct, right? The law of gravity is a constant. If I were to, here's a pen. If I were to drop this pen in Syria or in Somalia, where they don't really have functioning courts, at least not how we understand them, this pen would still hit the ground. The law of gravity applies. The rule of law does not. The rule of law is a construct. It's built by people, it's maintained by people, and it can be undermined and destroyed by people. But we've been incredibly fortunate in this country to have a rule of law ethos that guides how we do our work, meaning that we care about precedent. We respect the decisions of courts, right? If you think about it, it's rather extraordinary. The Constitution established the Supreme Court of the United States. And in the Federalist Papers, including in Federalist 78, Hamilton writes about how important it is to sort of abide precedent and to respect rulings, and that rulings that we abide and precedent gives us stability and continuity in the law. But nobody ever passed a law to say that. And in 1803, sorry about the digression into history, it's really interesting stuff. In Marbury versus Madison, the Supreme Court said it's our job to say what the law is. And everyone just sort of fell in line with that. And that has been the rule for us in the United States ever since, that the courts say what the law is, that they have the final interpretation of the law. And we've accepted that, thank goodness. But it really is sort of remarkable. It doesn't come from statute. It comes from practice.
Yeah, that is interesting. And sort of boning up on my history, the fact of what the Constitution did, it did not say in establishing the Supreme Court and other inferior courts as Congress may see fit over time. Right. It didn't prescribe numbers, qualifications, tenure. Obviously, it came to be George Washington. I think it was 6 justices. It has gotten as high as 10.
Yep.
But since we're on that topic, and obviously with the passing of Justice Ginsburg and the nomination of her replacement, there's been some talk about court packing. Can you tell the audience a little bit about where that term comes from and what it's meant over time?
Sure. So first of all, you impressed me with your knowledge of history, Eric. But
this is it today. It's all in.
So the Constitution established the Supreme Court, but did not set the number of justices. The number of justices was first set in 1789, the Judiciary Act of 1789, which, as you noted, Eric, set it at 6. And between 1789 and over the next 80 years until 1869, that number fluctuated between 5 and 10. Finally, in 1869, under President Ulysses S. Grant, the number was set at 9, and it's been 9 ever since. But it was set by statute, which means it can be changed by statute. And so from time to time, there have been proposals by various politicians for various reasons to change the number of justices, usually to increase it. The most famous one was FDR, Franklin Roosevelt, in 1937. A lot of his New Deal legislation was being overturned by the Supreme Court. He was incredibly frustrated. And so he came up with an idea to put more justices on the court, those favorable to his view, and then therefore a larger court, 11 or 13, however many, would have enough justices to sustain legislation that he was seeking to help get the United States out of the Great Depression. That was defeated. In fact, it was ultimately withdrawn. But I found this really interesting thing, again, history nerd, but William Taft, the only person to be both the Chief Justice of the Supreme Court and the President of the United States, lectured at Yale in 1912. He was an alumni of Yale. And he gave this talk about how court packing, this idea of adding more people to a court, was a very bad idea. I haven't yet found out what was going on in 1912 that triggered Taft to talk about that, what raised his concern. But here's the problem, Eric. Let's say, just pick a party, the Democrats control the House, Senate, and the presidency in 2021. Could they put more justices on the Supreme Court? Sure, it'd be relatively easy. Pass a bill and the president signs it. But imagine 8 years later, the Republicans control the House, Senate, and the White House. 2029, they could increase it further. Here's what worries me. The politicization of the court, right? You would be making the court more like the legislature. It would reflect the views of whoever is in power at the time. And our court has never been that. Sometimes it's been good. Sometimes it's been not so good. It's issued some horrifically bad decisions. But it has always been perceived by the majority of Americans as an other in American life, as apolitical. And I really fear that if we get into a court packing cycle, there's no way out of it. and the court becomes just more like the rest of government.
And you and I have talked a little bit about it. It almost fits into that can versus should. As you said, if one party controlled the House, Senate, and the White House, they can do it. I mean, they would have the authority to pass the legislation should they do it. And there has been, I would say, a fair amount of restraint from both parties, knowing what the blowback could be. Maybe some of it just to norms and fair play and realizing, as you said, where that path could lead.
Well, and we've seen it. Here's an example of how it sort of degenerated in another context. So for years and years, decades, the Senate had a filibuster rule. It was abolished by the Democrats in 2013, I believe, to help then President Obama get federal circuit court judges through the process. So federal court of appeals judges. But it was retained for Supreme Court justices until it was abolished by the Republicans for Supreme Court justices, right? So there is every action has an equal and opposite reaction. If the Democrats got rid of, and I'm not interested in trying to figure out who started it. I'm sure that there are scholars of the Senate who can trace this back much further than I can. But the notion is that there is always, right, something else that you can do to your opponent because you can do it. To your really important point, Eric, the question ought to be, should you do it? The fact that something might be lawful doesn't make it appropriate. And those are the norms that have always governed or should always govern the way we conduct ourselves.
And as you know, I think you and I and everybody listening also knows, history is sort of replete that a justice is nominated and confirmed, but they may turn out very different than once they're seated. So we nominate humans to the court, and people continue to grow, evolve, change.
And to that point, Eric, I mean, the Constitution gives them lifetime tenure, as it says in the Constitution, for good behavior. So assuming they behave well, they're on the court for the rest of their life. They're beholden to no one. Here's a really good example. In fact, two really good examples, and they're kind of cool. In 1973, the Supreme Court rules that President Nixon does not have executive privilege that he can assert to prevent him from turning over tapes and documents subpoenaed by the special prosecutor in Watergate. The ruling by the Supreme Court was unanimous, 8-0 against Nixon, including 4 justices that he appointed. Fast forward to the presidency of Bill Clinton in Clinton v. Jones, in which the Supreme Court unanimously ruled that a president, in this case Clinton, had to sit for a deposition in a civil case for conduct that allegedly occurred before he became president. The Supreme Court was unanimous that he must sit for that deposition, including 2 justices appointed by President Clinton. So this, I think, buttresses what Chief Justice Roberts had said recently. Don't think of us as Trump judges or Obama judges. Just think of us as judges. We're trying to do our best.
And obviously, we're again in another fascinating time in history as we head into an election and the passing of Justice Ginsburg and what this confirmation will look like. And I think we can kind of predict what it would be, but often we're wrong. So again, when we first conceptualized this talk, we didn't know this would be a topic, but I think it's going to be at the forefront of many people who are listening. Turning a little bit now to the Attorney General, and you, as I said, you've served a number of Attorneys General, both in Democratic and Republican administrations. I think going back to Dick Thornburg, William Barr's first assignment as Attorney General, then Janet Reno and John Ashcroft. Did I miss anybody in that?
Inevitably, yeah. I mean, I'm trying to think of everybody who might have been there briefly or in an acting capacity, but yeah, you more or less have it.
Yeah.
Right.
It suffices to say you've seen how the job, quote unquote, the job has been done by different folks, different philosophies. Obviously the Attorney General now, I think it would be helpful for our audience to go back to what is the role of the Attorney General? What are his or her authorities? What parts are norms? What part are statutes? There's been some talk and some confusion maybe in the public sphere of who is the chief law enforcement officer of the United States?
Well, so lots of good and hard questions. The chief law enforcement officer of the United States, we have always said, is the Attorney General of the United States. The entire power of the Justice Department is vested by statute in the Attorney General of the United States. Now, of course, Eric, and I think this is what your question is getting at, the Attorney General has a boss. It's the President of the United States. And so, just as the President is the Commander-in-Chief or the Chief Diplomat, you can make an argument, I think not a frivolous one, that the President's also the Chief Law Enforcement Officer because somebody subordinate to the President is called the Chief Law Enforcement Officer. And, that makes sense on a day-to-day basis. It is certainly the Attorney General. But there was another really important question embedded in what you just said. So the Attorney General is both a member of the President's cabinet and therefore a political actor, and appropriately so, right? We can think of lots of things that attorneys general do that are political in nature and that don't trouble us at all, like perhaps helping the president on policy initiatives or legislation or the selection of judges or making grants, right? All appropriate, quote unquote, small p political roles for an attorney general. But there's also this really incredibly fundamentally important thing that an attorney general does, which should never be political, which is oversee the criminal enforcement mechanisms of the Department of Justice. You were an FBI special agent for most of your professional life. There are 4 law enforcement agencies within the Department of Justice: the FBI, the DEA, the ATF, and the U.S. Marshal Service. There's also the entire U.S. attorney community, which prosecutes federal crimes in coordination with all of these law enforcement agencies I just mentioned. That work can never be politicized. And if an attorney general politicizes the criminal enforcement mechanisms of the US government, of the executive branch, then we are in deep, deep trouble. And so you have this political hat that you appropriately wear as attorney general, and you have to have this non-political, apolitical hat that you wear as the person in charge of the criminal enforcement mechanisms of the federal government.
It's a very unique role in that, as we've talked about, the Secretary of Treasury, if there's certain fiscal or monetary policies that the president wants them to pursue, they will do it. The Secretary of Commerce, cabinet members, but it's sort of that duality of the role of the Attorney General. And I think, and bring it back to the church committee, but I think we saw in the 70s, and you and I, kind of before our prime time, but I think, we both saw that one-page document that was signed by then Attorney General Robert F. Kennedy, authorizing the FBI under J. Edgar Hoover to wiretap Martin Luther King sort of without limit. And it was a one-page document. And personal opinion, that was where you have an administration using a willing FBI to do wrong. And then sort of the corrective action of what came out of it, including what the church committee did. But we're in an interesting time now, and I know that you've commented. Talk a little bit about what you've seen as far as the independence. What has led historically the attorney general to wear that independent hat, apart from just the duties as a cabinet member?
Yeah, again, it goes back to what you said at the beginning. It's the respect for norms, right? So where is it written that an attorney general has to sort of defer to career federal prosecutors? In fact, what is written is quite the opposite. What is written is that the entire authority of the Justice Department is vested in the attorney general. It means he or she can do as they see fit, more or less, as long as it's not illegal or unethical, right? They can have us take certain positions in court. They certainly do in the Supreme Court and on civil matters. Where attorneys general have tended to stay away and defer to career agents and prosecutors is in criminal enforcement matters, right? So fraud cases, you name it, public corruption work, crimes against children, violent crimes, healthcare fraud, right? The meat and potatoes work of FBI agents and federal prosecutors day in and day out in offices all across the United States. And that's the stuff that attorneys general have left alone, and appropriately so. Now, there are some very, very high profile cases where you would expect an attorney general to be briefed, right? Because of the ramifications. There might be national security ramifications to a case. I'm not saying they have to state that they have to be ignorant of what's going on in the criminal enforcement work of the department, but they shouldn't interfere. And if they do interfere, they have to be very, very, very careful that it's not for political reasons. And that's where I get into that point, Eric, that you and I have talked about our work both being fair and appearing fair.
And you wrote an op-ed about that in the Washington Post, and I guess that's a good segue into maybe a recent case that people would at least be a little bit familiar with, and that's Roger Stone and sort of commentary by the Attorney General, the President, actions of the prosecutors. Can you talk a little bit about, is that the norm? Are there prohibitions against commenting on that, and what governs that?
So it is not the norm. It is quite apart from the norm. It's about 180 degrees from the norm. But are there prohibitions? Again, the prohibitions are based in norms, right? So when the Attorney General believes that the position of the United States in Roger Stone's sentencing was too severe, does he have the legal authority? And Stone, I'm sure many of your viewers know this, but Stone was an ally of President Trump, who got himself in a spot of trouble with the special counsel's office, was charged, convicted, and was pending sentencing when the Attorney General weighed in on his behalf, ordering federal prosecutors to make a different sentencing recommendation to the federal judge who was going to sentence him. Highly, in my view, inappropriate, not illegal, because again, the entire authority of the Justice Department is vested in the Attorney General. It might be the case, Eric, that the sentencing guidelines that were applicable to Mr. Stone were, in Bill Barr's view, too severe. That's a policy issue.
Reasonable people can disagree.
Absolutely. But if they were too severe for him, they were probably too severe for others like him around the country also facing sentencing for, if not perfectly similar conduct, like conduct. But to only intervene in one case in which the president has, criticized prosecutors and tweeted voluminously about injustices done to Mr. Stone makes the work of the department appear to be unfair. Now, that's why I say we have to both be fair. I mean, actually fair, objectively fair. We have to ensure that defendants get all of the rights to which they're entitled. Due process, discovery, you name it, advice of counsel. They have to get everything. And we have to appear to be fair. Because if we're only fair, but we don't appear to be fair, people lose confidence in our work. And that's what was so troubling, I think, about what Mr. Barr did. He intervened in a case that the president cared deeply about, and he only intervened in that particular case. Well, he also intervened in another case the president cared deeply about, General Flynn. But other than that, either we don't see it, we're not privy to it, Eric, and it's happening elsewhere, or it's not happening elsewhere, and the department is favoring people that the president cares about.
And I guess depending on your outlook, again, trying to look at this in the spectrum, the bell curve of maybe thoughts on this, some would argue that the Attorney General and the President are playing in the four corners of their authorities, and not doing anything that is statutorily or constitutionally prohibited.
I agree.
On the other hand, other people would say they are violating a host of norms for reasons that to some are unacceptable, inexplicable, indefensible.
Yeah. So, but I think those two things you just said are perfectly compatible. Well, they're legally compatible. They are, let me say it in English. They're not doing anything illegal or unconstitutional, but they are violating the norms of the Department of Justice. And that's why you see letters signed by hundreds and hundreds and hundreds of DOJ alum, right? Former federal prosecutors who say, this is not the way we behave. We don't sort of grant favors to friends of the president who occupies the White House. Now, by the way, I can give you an example of President Clinton doing something like this, which many of us found deeply, deeply troubling, right? On his last day in office, I believe he granted a pardon to a fugitive financier named Mark Rich, somebody who was indicted and fled the country, nevertheless got a pardon by Bill Clinton on his last day in office, one that Eric Holder, then the Attorney General, he probably was a bit queasy about it, but nevertheless recommended to the president. I think Holder later said it was a mistake. It was a huge mistake because we don't do favors. We treat everyone fairly and similarly. And when that breaks down, right, people lose confidence in the work of the Department of Justice. That's why we have to be fair and appear to be fair.
Yeah, and it sounds sort of trite and cliche, but you probably heard the same thing that I heard routinely. When you're considering your actions and the can, should, and looking at the norms that governed our behaviors, is, how would our behaviors, our actions, our decisions look on the front page of the Wall Street Journal, the New York Times, in the light of day? Right. And I found that always, I never took that as restrictive. I always looked at that as saying, okay, we work in the light, and, we try and do the best that we can. We make decisions, and if we make errors, we own them. Right. But again, this is not a one administration of the other. I think that, again, the Mark Rich pardon, I was in the FBI at the time, and I remember saying that doesn't smell right. And then fast forward to the Roger Stone time. We've covered a lot of things right now, and I've got a lot more to cover, but I just thought, Garry, any questions on sort of the first few topics before we move on to some others?
Yes, let me ask a question here that was posed. What do you say to critics who claim that Robert Mueller could have done more to hold President Trump accountable?
So great question, Garry. So first of all, let me tell your viewers that I am biased. Whenever I'm biased, I like to tell you flat out, I am biased. I worked for Robert Mueller on his staff at the FBI after 9/11 as his counsel for national security. I think the world of that man. It was one of the great professional privileges in my life to have been on his staff. And Eric, I imagine you feel the same way because you were on his staff many years later.
Yep.
So, Garry, here's my answer to your specific question. Bob Mueller is extraordinarily scrupulous. He's a man of tremendous dignity and integrity. I think that what he did was completely appropriate and within the charter of what he was asked to do. He wasn't asked to opine about the president's behavior, right? He wasn't asked to charge the president because Department of Justice policy precludes charging a sitting president. One of the criticisms of Mueller, and I completely get it, is that it seems sort of hard to tell in volume 2 of his very, very good 448-page report whether or not Mueller thinks the president obstructed justice and therefore broke the law. I think Bob Mueller would explain it the following way, and this gets to your question. If you can't charge a sitting president, and Department of Justice policy precludes it, and by the way, that policy was formulated under Nixon and Clinton, not under Trump, then you should not be able to, in writing, claim that a president committed obstruction of justice. Why not? Right? The notion behind charging someone is that they get their day in court. They get to defend themselves. The charges are public, and you can go to court and you can argue for your acquittal, and you can have a judge and lawyers help you in that process. But if you simply assert that someone committed a crime and you never bring charges, then you don't give them that opportunity to clear their name. And I think the Mueller team saw that as fundamentally unfair and that it constrained the way they wrote their report. I get it. It's kind of frustrating to read it. And what I see in volume 2 particularly is, close to a dozen different obstructive acts by the president of the United States that had they been committed by Eric Barnhart, he would have been charged, convicted, and incarcerated. But Mueller is so scrupulous and so careful, and I think bent over backwards to be fair to the president, which was appropriate under these circumstances, that he didn't come out and say he committed a crime. Now, there's also, Garry, nothing that precludes a former president from being charged. That's a very difficult discussion, which we should save for another day because it's layered and complex. But I understand what Mueller did and why he did it.
Thank you for that explanation. We have another question. You referenced the Frank Church Committee investigating the CIA and the FBI. And one of the results of that investigation was the passage of the Foreign Intelligence Surveillance Act. How well do you think this has operated, and does it need to be revised?
So the Foreign Intelligence Surveillance Act became law in 1978, in very large part because of the work of the Church Committee and the Pike Committee in the House. It's worked extremely well. We do thousands of FISA applications to this court in some of the most important sensitive cases that we have, mostly counterintelligence and counterterrorism, or I should say exclusively counterintelligence and counterterrorism. But it's not perfect. And the Inspector General recently issued a report. If people can't read the whole thing, read the executive summary, because he appropriately pointed out a bunch of flaws in FBI procedures to review FISA applications before they were presented to the court. Now, importantly, the Inspector General didn't find that the work was infected by politics, the thing that Eric and I spoke about at the very beginning. But he did find procedural flaws. It has to be fixed. Judges have to have confidence in the stuff we present to them when we ask them to sign warrants that authorize very intrusive behavior, Garry. Right now, so Eric, how many, as a special agent of the FBI, how many times did you go to a federal judge for seeking a search warrant?
Hundreds.
Yeah, and as a federal prosecutor, the answer would be the same for me, hundreds. And what sort of care did you take in preparing those affidavits that you presented to the judge?
You owned every line. I mean, it was, you wrote that knowing that you would have to potentially defend everything that was in that affidavit, whether it be a suppression hearing, a legal proceeding where, again, the defense would go line by line. Great care. You weren't fast and loose with that. I mean, I remember the first time that I applied for a wiretap affidavit, it was 70 some pages because it is one of the most intrusive techniques, and a FISA warrant being likewise the most intrusive method that we use, and great care must be taken in utilizing that.
Right, and in the hundreds of warrants that you did, and probably the thousands that occurred around you by colleagues and in offices that you supervised, did anyone ever screw that up?
Yes.
Right, because we're human beings.
Yep.
We make mistakes, and our obligation when we make them is to fix them. What happened to the FBI in a number of these high-profile FISA warrants is they screwed things up. The Inspector General pointed out, the new director, Chris Wray, has put in a bunch of procedures that I hope will catch future mistakes. But Jim Comey made a point the other day, Garry, when he was testifying about this very question. And he said too, it's an incredibly important process, and one that we have to keep. We must keep this authority to help protect our country, and I completely agree. But the FISA process is overlayered. The FISA warrants go through so many different sets of hands and so many different sets of eyes that the thing that Eric just described, right, owning every line, doesn't tend to happen because responsibility is spread out over dozens of people for each FISA warrant. If Eric were my case agent and I were his prosecutor and we were bringing a search warrant to a federal judge in Boise, Idaho for her authorization, the two of us would be on the line for it. And we would make damn sure we got everything right. But if we had 40 other people also responsible for it, I actually think there's a chance that the product gets worse and not better. I don't know if you have a feeling about that, Eric.
Well, I remember, my first, having done my first wiretap and being on the stand for the better part of a day, as probably 6 to 8 defense attorneys went line by line through 60 to 70 pages of my affidavit, trying to show that I was either wrong or willfully omitted or willfully misled the court for them to authorize the wiretap. That is a extreme ownership situation. The first one of those that you go through, that whole process is driven home. And I agree. It's a single point or maybe a dual point of failure if Chuck and I fail in that process on the criminal side. On the national security side and for the FISA court, it's a much different process. It doesn't mean that the standard demanded by the Constitution of the American public should be any less. It's a different one. It needs to be fixed. We need to maintain the confidence of the American public. so we can maintain a very vital tool. But fixes need to happen there.
Agreed. Well said.
Another question. When the administration sent federal troops to Portland that were not requested, was that a case of overstepping criminal enforcement?
So the answer, Gary, is a huge perhaps. So federal agents have been in Oregon for a century. I think the FBI opened its office in Portland in 1920. So do federal agents have the authority to be in states enforcing federal criminal law? Absolutely, no question about it. In Oregon, I believe, and Eric, correct me if I'm wrong, there's a state statute that permits federal agents to enforce state law as well.
Yes.
Now, if agents are sent to Portland, let's say, Gary, to protect the federal courthouse from arson, people are trying to, or even just damage, is that an appropriate use of federal law enforcement? Sure. Protecting federal property or federal officials from harm is absolutely an appropriate use of federal law enforcement. The really hard question comes when they stray from that mission. So now, if federal agents dispatched to Portland, let's say to protect the Portland federal courthouse, are now 7 blocks from the courthouse, 10 blocks from the courthouse, 15 blocks from the courthouse, doing other things, I think that's problematic. And so the question becomes, what is it they're doing? And are they sticking with the appropriate mission of defending, let's say, federal property or federal officials, or are they straying from it? And now, in this case, it wasn't the Justice Department, as I understand it. It was federal agents from the Department of Homeland Security that do not fall under the Attorney General, but still fall under the President. And it's unclear to me that they were strictly abiding, sort of the mission I described. And that's where it becomes problematic. The other thing that a place like Oregon could do, I think in most states, most state legislatures have granted to federal agents the ability to enforce state law within their confines. Not every state has. But if we abuse privileges, they can also be taken away. And so if the legislature in Oregon is very upset with the Department of Homeland Security, they could, in theory, strip from all federal agents in Oregon the ability to enforce state law. I think that would be a bad thing. Eric, have you ever enforced state law as a federal agent?
Yes. Yeah. And again, there is that statute in Oregon where I served twice, and other states. This is another one of those. And I don't want to second guess decisions that were made by our former colleagues in the FBI because I don't know everything they know. I'm an old guy on the sidelines now. I can tell you that if they came to me and said, we want you to do this in Portland, I would first say, what are our legal authorities? What is our well-defined mission? But having served in Portland and any number of other places, there's also sort of that, I always took a philosophy in my last job, no better friend, which I borrowed from General Mattis. He said, no better friend, no worse enemy, but the no better friend. And that was my philosophy in working with our state and local partners. But there were times where they would say, can you help us out? And I would have that conversation. I can't. Do you really want me to, or is this going to make a bad situation worse? And that doesn't mean that we're going to let lawlessness or anarchy reign. It's just, that is part of the can versus should, I think, sober, mature conversations that need to happen between different law enforcement jurisdictions of, are we going to help or hinder this in a broader scale? I think there's people of goodwill that can debate that back and forth.
I think I'm sorry, Eric, excuse me. I was going to say, I think when federal law enforcement gets involved in what is ostensibly or primarily a state matter, to Eric's point, they have to be really, really careful about defining the mission, making sure that they're adding value, that they're not sort of overreaching or overstepping. But, Gary, imagine Eric as an FBI special agent on a day off, walking in a park in Boise, where he sees a woman being assaulted by a man. It's not a federal crime. They're not on federal property. She's not a federal official. Would you want Eric to be able to intervene as a law enforcement officer? And the answer is, of course you would. And so, we have to be careful before we sort of throw the baby out with the bathwater. We may not, the notion that we would strip federal agents of this authority I think could be a dangerous one. On the other hand, to Eric's point, if they're going to be assisting state law enforcement in the enforcement of state law, we have to very well define their mission.
Okay, we have two questions that are related here. If we consider that President Trump has violated many norms during his time in office, what steps can be taken to rebuild trust in a post-Trump era? And related to that, should the federal government pursue cases against administration officials who violated the law?
Yeah. Let me take the second question first. I think this is one of the most fascinating chapters in recent American history. So Nixon resigns, Ford becomes president, and Ford pardons Richard Nixon. And Ford is excoriated by the press and by politicians, mostly Democratic politicians, of course, for pardoning Richard Nixon. Nixon committed crimes for which he could have been prosecuted now that he was no longer president. No question about it. And what Ford said, he actually agreed to testify in Congress about this. Imagine, it's sort of hard to imagine the president agreeing to testify in front of Congress, but he did. He said, as a nation, we need to look forward and not back. Ted Kennedy, then a liberal senator from Massachusetts, was one of those who excoriated Ford, said he was completely wrong. It was a terrible miscarriage of justice. Garry, 25 years later, Ted Kennedy presented a very old Gerald Ford with the John F. Kennedy Profiles in Courage Award at the Kennedy Library in Boston, Massachusetts. Kennedy said, over this last quarter century, I've thought a lot about what Gerald Ford did. And he was right and I was wrong. He was exactly right that as a nation we needed to move forward, that a new president and a new administration should not be mired in the misdeeds of the one that preceded it. I know people feel very strongly that Donald Trump and others should face the consequences of their conduct during this time in office. I'm not one of them. And by no means do I condone what this president has done, because I do believe, if you read volume 2 of the Mueller report, that he committed criminal offenses. But I really worry about a nation that has lots of problems that it needs to solve, spending the first 18 to 24 months of a new presidency looking backwards and not forwards. And so I take the lesson of Gerald Ford and Ted Kennedy. I take the lesson of the Ford pardon. I think Ford was exactly right to move forward. And that might be an incredibly frustrating answer to some people, but we got lots of problems we need to solve. We need to do it together. And if Joe Biden wins in November, and I don't endorse anyone and I don't take any positions on politics, I hope the new president helps us heal and move forward, and we don't spend a lot of time looking backwards.
Another question, as a former administrator of the Drug Enforcement Administration or agency, what is your view of the war on drugs?
Well, I hate that term. I never use the term war on drugs. We are not a military unit, and I thought it was a ridiculous way to characterize the work of the DEA when it was created, and I think it's a ridiculous way to characterize the work of the DEA today. So my view is that most of the drug problem in America is a public health crisis and not a law enforcement issue, right? That we ought to stop. And I'm not saying we ought to. This is not about decriminalization, but that when it comes to people who are addicted to drugs, we ought to think of that as a public health crisis. At the other end of the spectrum, Garry, are very, very violent and dangerous cartels and gangs that distribute poison on the streets of America purely to make money off of people who are addicted to drugs. And so there is absolutely an appropriate role for drug enforcement, whether it's DEA or FBI in the United States. And that's where I tried to focus our work, at the very, very top of that distribution chain. One of the things I worry about, and Eric and I have talked about this, is that if you measure the work of law enforcement in terms of quantity rather than quality, you push the work down the chain, right? If Eric, who was the special agent in charge of the Salt Lake City field office of the FBI, was told that he needed more arrests next year than he had last year, he could find a way to do it. It would be easy. But the way he would do it would be by going after less serious cases to get his numbers up. And so I think we have to sort of detach the work we do from some quantitative analysis of it. And what I tried to do at the DEA, maybe successfully, maybe not, was to urge that we do big, important cases and that we ignore small, unimportant cases. And that sounds pretty obvious. But if you're insisting from year to year that we make more arrests, we have more indictments, we have more wiretaps, then you're going to push the work down the chain. And again, at the bottom of the chain, it's a public health crisis, not a law enforcement issue. Eric, I don't know, in your observations, I mean, the FBI does a lot of drug enforcement work, but not nearly as much as the DEA. Do you have a view on that?
Yeah, look, I'm going to echo your sentiments. Again, it sounds cliche, but we often said this is a problem that we're not going to arrest our way out of. And it is a huge public health crisis. And you're right. I mean, I think one of the things I struggled with for 22 years in the FBI was, how do we measure impact? And, we could arrest 57 lower level folks, and some people would say, hey, you've had a big impact in the community. Turn that around, if we had taken off the top 3 people, would we have had the greater impact of people that were truly poisoning our streets, truly running these cartels? It's a problem faced by law enforcement every day. And again, I think it's an area that we need to be a lot smarter at and recognize where law enforcement solutions start and end, and where the public health crises has to be addressed. I'm in the camp that I think too often we're asking folks without that training to venture into areas that they don't have the expertise.
If I could add one thing to that, Eric.
Yeah.
If anybody should have the luxury of doing big, important cases and not worrying about, numbers, it should be the federal government, right? And I'll give you an example, Garry. I had the privilege when I was U.S. Attorney in the Eastern District of Virginia of supervising the tail end of the 9/11 prosecution. Big, important case, took 4.5, 5 years from start to finish. We had 4 assistant U.S. attorneys, an entire squad of FBI agents, analysts, support from Main Justice, all working on what turned out in the end to be one conviction. Was that a good use of our time? And my answer is absolutely it was, right? I mean, could I have deployed those resources in some other way, right, to get more, drug convictions or immigration convictions or bank fraud convictions? You bet. Right? We could have run up the numbers if that was our goal. But successfully prosecuting the 9/11 case in federal court was what we ought to be doing in federal law enforcement. And so I really, really worry about the tendency in law enforcement generally to emphasize quantity over quality. And remember too, federal law enforcement is a very, very small part of American law enforcement. There are 18,000 law enforcement agencies in the United States. Eric, how many special agents in the FBI?
About 13,500, 37,000 total employees of the FBI.
So
very small.
13,000 and change FBI special agents, making it 1/3 the size of the number of uniformed officers in the New York City Police Department. Think about that.
There's approximately, I think, about 900,000 law enforcement, state and local tribal officers compared to, again, a very small number of federal agents across the various agencies.
Right. So that's exactly right. I mean, I've heard 1 million, but let's say 900,000 to 1 million law enforcement officers in the United States. The number of federal agents are in are a small fraction of that number. And so the problem that you described, Garry, in your question is a huge one. And we have to look at ways to think about enforcing law that emphasizes the quality of our work over the quantity of our work.
So a related question, which critical areas of law enforcement are being ignored as we spend so much time focused on the Trump administration?
So here's a hopeful, optimistic answer, which I hope is not wrong. You have to remember that there's a lot of oxygen being consumed by our focus on the Trump administration and the Mueller team. But on a day-to-day basis, Eric, you were more recently in government than me. The men and women of the FBI, the U.S. Attorney community, the DEA are doing the day in and day out stuff. Has that really changed very much, Eric, from your perspective?
No. you said it early on in this conversation, Chuck, just the notion that what goes on in politics and at that level just bears so little impact to the great work that goes on a daily basis. The people that I worked with knew that administrations and priorities changed and policies changed. But, if you talk about people doing work, crimes in Indian country, crimes against children, organized crime cases, large white collar crime cases, I don't mean to minimize it, but a lot of what we see on cable TV and in the media in general is just background noise. They have a job to do. These are people that, in my experience, have an incredible sense of right and wrong, a sort of righteous indignation about what's right and wrong. And it sounds, again, trite. They're too busy doing the day job to get caught up in a lot of these things. I've talking to former colleagues, the work goes on.
Yeah, that's my impression too. The work goes on. The cases are being investigated and prosecuted in ways they always have been. A lot of attention is being paid to a very, very small sliver of the pie.
So our hour is drawing to a close. I want to thank Chuck Rosenberg and Eric Barnhart for their timely presentation. Note the next Fridays with Frank will be held at 10 a.m. Friday, October 16th, with Liz Schreier, president of the U.S. Global Leadership Coalition. For student viewers, please join the Boise State All-Campus Challenge by going to idahovotes.gov. The stakes are too high for you not to vote. And thank you again, Eric and Chuck, and good day to you.
Thank you.